What happens when a legal dispute arises between two people living in different countries? What court should decide the case? What law should apply? This is where the rules on conflict of laws come into play. Hello and welcome back to the channel. In today's episode, we'll try and understand some of the basic principles on conflict of laws. Let's get started. Conflict of laws, also known as private international law, is a set of rules that determine the courts and the applicable law in cases where disputes involve multiple jurisdictions. With the world becoming increasingly interconnected, it's not unusual for disputes to arise between people and companies from different countries. And in such cases, the rules on conflict of laws are used to ensure that a fair and just outcome is reached. The rules on conflict of laws apply to a vast range of legal issues, including contractual disputes, tort claims, property law disputes, family law disputes, etc. For example, let's say that person A from Sri Lanka enters into a contract to export tea to person B in England. If person B refuses to pay for the goods, or the goods shipped by A are not satisfactory, a contractual dispute arises between the parties. The question becomes, where should the case be heard? Sri Lanka or England? And secondly, what law should apply in resolving the dispute? Sri Lankan law or English law? Of course, there are areas in which conflict of law rules don't apply. For example, conflict of law rules don't apply to criminal cases or public and administrative disputes. First, let's talk about how to determine which court has the jurisdiction to hear the case. Jurisdiction to hear a case refers to the power given to a particular court to hear and resolve a dispute. Usually, if a dispute arises between two individuals from the same country, then the appropriate court of that country will have the jurisdiction to hear the case. For example, if I buy a loaf of bread from a local shop and the bread has gone bad, the courts of the country where both the shop and I are situated will have the jurisdiction to hear the case. When the case involves multiple jurisdictions, it's important to understand which jurisdiction has the right to hear the case. For example, if someone buys something from an online store like Amazon situated in America, and the buyer is from India, and something goes wrong with the order, where should the action be initiated? In the United States or India? Now, there may be several rules that need to be considered when deciding which country's court has the jurisdiction to hear a case, but the general rule is that the case will have to be filed in the country where the defendant is present. What this usually means is that the country in which the person against whom the case is being filed will be the country that has the jurisdiction to hear the case. But it is important to understand that there are several exceptions to this rule which may need to be considered. One popular exception to this rule is in contracts where the parties have agreed on the jurisdiction in the agreement itself. So, for example, the parties from India and the United States can have agreed in the contract that any dispute will be heard in the courts of England. In such a case, the correct place to hear the case will be England because the parties have agreed to that place in their agreement. Once the jurisdiction has been decided, the courts will have to decide which country's law will apply to the dispute. Basically, the case can be heard in England, but it might be the French law that has to apply. So then the English judges will have to use the French law to resolve the case. I know it sounds a little strange, but this is actually how it happens. In such cases, the courts will get an expert on French law to give evidence to educate the English courts on the French law so that they can make a decision. So how do we find out which law applies to a cross-border dispute? Well, this will depend on the connecting factors that will apply. Basically, different types of disputes have different connecting factors that will apply, which will help determine what law applies. In tort or delict cases, for example, the connecting factor will be lex loci delicti commissi, which means the law of the place where the tort or the delict happened. Let's say a German national while on holiday in Sri Lanka met with an accident with a car driven by an Australian national. In such a case, the law that would apply to the dispute will be the Sri Lankan law because the tort was committed in Sri Lanka. Similarly, there are different connecting factors that will apply to different types of disputes. For disputes arising from a contract, for example, the connecting factor is usually lex contractus, which means the law which governs the contract. This is why it's important to clearly set out a choice of law clause in your contract itself. If you want to learn more about how to do this, you can check out my video on it. I'll leave a link to it in the description below. Things, however, get a little more complex because there is no universal standard on what connecting factor applies to what kind of dispute. So depending on the country that is here in the case, the connecting factor that applies may vary. Another aspect of conflict of laws is the enforcement of a foreign judgment in another country. Let's say, for example, you get a judgment from India, but the defendant is situated in England. In such a case, it becomes necessary to take that Indian judgment and enforce it in England because that's where the assets are. When you're trying to enforce this foreign judgment in another country, then the other party does have an opportunity to object to that enforcement using certain defenses. So the courts of the country charged with enforcing this judgment will have to decide whether to allow this judgment into that country or not. So why do we have conflict of law rules? Well, they are important to ensure that cross-border disputes are resolved fairly and efficiently. It helps to prevent what is known as forum shopping. This is where the parties try to bring the case in a jurisdiction that is most favorable to them. The reality is, if I want to file a case against another person, then I want the courts and the laws that are most favorable to me. Similarly, the other party will want the courts and the laws that are most favorable to him. This could lead to serious complications with the same case being heard in different jurisdictions using different laws and two different judgments being given for the same dispute. Conflict of law rules prevents this from happening by setting a standard set of rules to find out the best court and the best law to determine the case. As our world becomes increasingly smaller and more interconnected, conflict of law rules become more and more important. With more and more businesses operating globally and consumers making purchases across borders, conflict of law rules in the digital realm are becoming more prevalent. Courts and legislators are constantly faced with issues of jurisdiction and choice of law in these online transactions. Of course, conflict of law rules are far from perfect, but it does provide some clarity in an area which would otherwise result in chaos. In conclusion, conflict of laws is a vital part of international law. It helps to ensure that legal disputes are resolved in a just and fair manner, regardless of where the parties are situated. Anyway, that's it for this episode. If you do like this kind of content, please do consider liking this video and subscribing to the channel for more content like this. I'll see you in another episode. Take care. Bye.